Answer. I call on Government Orders of the Day number 1 to 3.
Immigration Amendment Bill number 2, Committee stage continued. Animal Welfare Amendment Bill, Committee stage. Objectionable Publications and Indecency Legislation Bill, Committee stage.
I declare the House in committee for further consideration of the Immigration Amendment Bill number 2, for consideration of the Animal Welfare Bill and for consideration of the Objectionable Publications and Indecency Legislation Bill. Mr. Chairman.
The House is in committee for further consideration of the Immigration Amendment Bill number 2, for consideration of the Animal Welfare Amendment Bill and the Objectionable Publications and Indecency Legislation Bill. Members, we turn first to the Immigration Amendment Bill number 2. When the committee was last considering this bill, Jan Logie was speaking and she has 31 seconds remaining. The question is that parts 1 and 2, schedules 1 and 2 and clauses 1 to 3 stand part.
Mr. Chairman.
The Honourable Michael Woodhouse.
Thank you, Mr. Chairman. I think at this time it would be appropriate for me, as the sponsor of the bill, to set out the substantive changes that are being proposed by the government's supplementary order papers, and also to address some of the issues that have already been raised by members, both in the commencement of the committee stage and also in the second reading. Questions actually much more measured in the committee stage.
Order. Mr. Bennett. I think if the member can resume his seat or sit beside the member he's talking to, it is quite rude to talk with your back to the minister who's speaking like that. The Honourable Michael Woodhouse.
Thank you, Mr. Chairman, and also to address some of the issues that were raised in a much more measured fashion, I think, at the committee stage than they were in the second reading, where things got rather emotive. And I just want to put some of those comments in context. And it is a disappointment to me for parties such as Labour and the Greens, I should just record, that understand the importance of protecting
To be working.
We don't mind.
Well, I'll do my best to speak into the microphone. Okay.
No,
I'll just raise it. Yeah. Clearly I was too tall for it. That it is disappointing to me, I have to say, Mr. Chairman, that Labour and the Greens are not supporting this bill, because I know they support the notion behind it, and that is that those who are being ill-treated, those legally able to work in New Zealand who are being exploited by their employers should be protected, and that those who are perpetrating those sorts of misdemeanours should be subject to a much heavier sanctions regime, which is the primary purpose of this bill. And it does sadden me that Labour and the Greens will not support that because of their concerns around some of the search powers. That seems to me to be the essence of their concerns that were addressed in the Select Committee, and I'll be very happy then if that's not the only concern, but I know that's been raised by both Labour and the Greens, but that has been passed comfortably, the Bill of Rights vet that's required to be undertaken by the Ministry of Justice. But I hold out hope that through this committee stage I am able to put at ease some of the concerns that the opposition members have, and to support this bill, because I know they support the goal. Now, in respect of the supplementary order paper, we are introducing a new offence. At the moment there is almost a binomial offence of the exploitation of a worker on a temporary visa, regardless of the employer's knowledge of their immigration status. Now, it has been drawn to my attention that there could be a defence of ignorance. And so what we are doing is saying that there should be another infraction, which is if the employer is reckless as to the immigration status of the employee, that in itself will be an offence. It still has some very severe provisions, punishments in it, 5 years in prison, up to 5 years in prison and up to a $100,000 fine. The supplementary order paper also makes some changes to the bill to align judicial review and appeal pathways to provide consistency between the two pathways. And it clarifies that an application for leave to the High Court firstly must be brought no later than 28 days after notification of the tribunal's decision, and secondly require leave to be sought before a party can appeal to the Court of Appeal. It also clarifies and amends Clause 19 to clarify that when a new visa is issued to a person whose visa is cancelled under the new cancellation provision of the bill, the new visa does not cancel the person's liability for deportation. Now, a subsequent amendment that I will acknowledge Mr Seymour on in respect of entry and search powers under Section 277A. Now, this is a clause that has given some members some anxiety, and in respect of Mr Seymour's interventions, the government has agreed to do two things. Firstly, through the table amendment, will require the Ministry of Business, Innovation and Employment to, within 3 years, review the exercise of the entry and search powers under that section and report to the Minister of Immigration on whether any amendments should be made to the Act concerning those powers. So often a review provision is brought into a piece of legislation if there are concerns about how it might be used. But in addition, the amendment will require that the Ministry will report to Parliament annually on the use of the entry and search powers under Section 277A. Now, I want to move to the three questions that were asked by Mr Lees-Galloway in his initial intervention in the committee stage. His first question was, why does the government choose to give the power to search private dwelling houses without warrant to immigration officers and not labour inspectors? Well, Mr Chairman.
Mr Woodhouse.
Thank you, Mr Chairman. This is the Immigration Amendment Bill. Effectively, without sounding glib about it, the reason we've chosen to give the additional search powers to immigration officers is that labour inspectors have no powers to investigate offences under the Immigration Act. But I would also add that often the investigative search powers that are required by immigration officers are much broader than that which will be required for work visas or in a work setting. So I'm perfectly comfortable that in respect of the Immigration Act, these powers are appropriately given to immigration officers. Now, I should also just note that the warrant for search can be sought by an immigration officer, but presently it can only be executed by a police officer. Now, that was a provision in the Act that had a sunset clause on it, and we are bringing that back. But I want to acknowledge also the questions that have been raised mainly in the second reading around whether these powers are necessary or appropriate, because it certainly does appear to be the thing that is giving some members anxiety. Now, in respect of those search powers, this will enable immigration officers to undertake a personal search at the border for the person's passport or identity document where the officer has reasonable grounds to suspect the passenger is concealing those documents. And I think anybody, any reasonable person would expect that at the border, those immigration officers should have the power to do that. But the third amendment is probably the one that gives members the most anxiety. Trained immigration officers would undertake a search of certain places for a passport or identity document in order to facilitate a deportation, and that they could do that without warrant. Now, the search doesn't need a warrant in the sense that the officer often doesn't know until they go onto the premises that a search is even necessary. We have the ludicrous situation at the moment where an immigration officer could walk into a person's premises, a person who could be liable for deportation. The passport could be sitting on the table in front of the person. But the immigration officer has no powers to require the documents to be presented. Now, that may sound utterly ridiculous, but my immigration officers tell me that is happening reasonably frequently. And these people simply either refuse to hand over or deliberately hide their passports in order to delay or impede their deportation. This power will allow our immigration officers to search the place where the deportee is located, their abode, their premises or their vehicle, if they believe the identity documents are in that place. Currently, the immigration officers can enter and search premises for the person in order to deport them, but not their documents. Now, I think that's ludicrous. That's why we're making the change. It's necessary in the field for the officers to have this power. And I would be very disappointed if that kind of, which has been Bora vetted, that kind of provision actually prevents parties in this House from supporting this bill. Two other issues raised by Mr. Lees-Galloway. The first one is the immigration levy. Is it really a tax? Well, there are very clear descriptions about what constitutes a levy and what constitutes a tax. A levy has to be levied for a specific purpose. And I can assure the member that the activities will only be related to the funding of the immigration system. It will meet the definitions of a levy. Well, the better example is the road user charges levy that the member held up actually is a good example. The levy is paid by road users to contribute towards the upkeep of our roads. Well, that's exactly what the immigration levy would do. It contributes to the upkeep of the immigration system. Lastly, Mr. Chairman, Mr. Lees-Galloway raised the question about why the bill contained a clause that allows regulations to be made that could override the primary legislation. Now, I can advise the member that, in fact, while that was the case when the bill was introduced, that has been removed by the Select Committee in second reading. So that provision that the member was concerned about that would override that primary ledge is no longer in the bill. I could give the member the specific point to the specific part of the bill if he wishes, and I'm sure officials could assist me, but I can reassure the member that that is no longer the case. Thank you.
Sue Moroney.